Good morning. This is the Senate Judiciary, Friday, April 22nd, 1943. Oh, excuse me, 2022. That was my birthday. We're going to start with proposed amendment to the Miscellaneous Judiciary Bill, which I believe is now on the notice calendar. It's been voted out of Finance. And Eric is going to walk us through it, and we appreciate Boer Yang being here to explain the proposed amendment. Sorry for keeping you waiting for.
No problem. Thank you for having me and inviting me to testify on this. Did you say it was your birthday, Senator Steers? Happy birthday.
Thank you.
So for the record, Boer Yang, Executive Director and Legal Counsel for the Vermont Human Rights Commission. The provisions of H3 29 that is now before you regarding the statute of limitations is not controversial. Currently, the plaintiffs have 3 or 6 years to file a lawsuit on the basis of discrimination. And the timeline for filing a lawsuit depends on the relief sought by the plaintiff. It's 3 years for personal injury, such as emotional distress, and it's 6 years if it's for other losses. Back pay, reinstatement, if someone is seeking declaratory relief or injunctive relief. 6 years is the default statute of limitations for most civil claims. So granting plaintiffs in discrimination claims 6 years is really clarifying that they have what is available to most civil plaintiffs. And it simply gives them the benefit of the 6 years, regardless of the relief that they seek. And the reason why this change is important is 3 reasons. The first is that having 2 separate statute of limitations is really confusing for plaintiffs, most of whom are unrepresented by attorneys. The second reason is that a 6-year statute of limitations gives agencies like the Human Rights Commission more time to complete an investigation before a claim is filed. As many of you know, we are chronically short-staffed and under-resourced at the Human Rights Commission, and people's rights of action are at risk of being lost while the HRC attempts to finish an investigation. But perhaps the most important reason, and the last one that I'll talk about, is that 6 years reflects the realities of most Vermonters, and that they face a housing market that has very little vacancy. Maybe less than 3% across the state, less than 1 to 2% in some areas. And if you're in a very small town, there may be no vacancy at all. There are limited economic opportunities for everyone, especially for people who have specialty skills, and even fewer specialists and clinics available to people who have specific chronic disabilities and illnesses. Plaintiffs are not going to file their claims until they have achieved safety and securities in these areas, and it can take years for that to occur. Just want to give an example. If a woman lives in a small town like Stockbridge, and she is facing harassment by her landlord, and her child happens to be going to that school and is doing well in that school, maybe her child has a disability, is on an IEP plan, she must make a choice between her child's well-being and her own safety and security. In order for her to keep her child in that school, she must find another home in that same town. And a simple Google search or Craigslist search will show you that there are no homes available. If she is lucky, from time to time, 1 or 2 may come up on the market, but they still have to be within her price range. And if she's even more lucky, the one that is in her price range, she has to cross her fingers that that new landlord doesn't want a reference from her current landlord. Again, she is faced with the dilemma of choosing between her safety and her child's well-being. We often hear from women in the workplace who face harassment, but who say, I'm not ready to file now because I have a promotion coming up in a couple of years that I think I could qualify for. Or, yes, my supervisor has done this really egregious thing, but if I file a claim against my employer, it's going to compromise my positive letter of reference if I move to a new place. I have to get that job first, get that reference first before that happens. So I just think that a 6-year statute of limitations is really reflective of the realities of most Vermonters in the workplace, in the community, in housing. And it can take so many years before they find that safety and security. And so for all of these reasons that I have mentioned, I just urge you and ask you to support this amendment to the bill. And thank you for giving me the time to weigh in on it. And I'm happy to answer any questions.
Any questions from board? I think it's a pretty good description of the problem, and glad you brought it to us, and I'm glad we still have the miscellaneous judiciary bill.
Thank
Senator,
you.
I'm just wondering, maybe a question for Boer or maybe a question for Eric. It just seems like a no-brainer to me, but I could imagine there being some interest somewhere that would oppose it. Is there opposition to this at all?
I'll try to my best to answer that, because it was primarily Damien, not Eric, that was in the House committee that heard 329. And my recollection is that this is clarifying and helpful to the parties. I don't recall hearing opposition. The committee did take testimony from a lot of attorneys that represented employees and employers. The committee heard from the Network for Survivors of Domestic Violence and Sexual Violence, Vermont Legal Aid, the opposition to 329, which was primarily from the schools, does not oppose making the statute of limitations 6 years, even in the school area. And so, like I said, this wasn't a controversial piece of the bill.
Okay.
And it is unrelated to why the bill did not make crossover.
Any, having been on economic development and tried to work on renters' rights, there was always intense back and forth there. Was there any testimony from people representing landlords?
Yeah, that's a good question. I don't recall that there was.
Okay.
Yeah.
So this is, I'm looking at the wrong thing. Yes. What would be the time frame now? 3 years?
So right now it's 3 or 6. It depends on the relief. So part of the issue here is that you're not turning a 3-year statute of limitations to a 6 years. Plaintiffs already have 6 years. They would lose out on some of those claims or that relief that they seek if they don't have the benefit of the full 6 years. And so I just wanted to clarify that 1, 6 years is available to most civil plaintiffs, and 2, 6 years is already available to these plaintiffs. It just depends on the relief that they seek.
So 2 or 6 is available right now?
3 or 6.
Oh, 3 or 6.
But what determines? I'm not clear on when it's 3 and when it's 6. Or is that
the type of the part of the claim that's at issue? So it might help if I gave a hypothetical, and might sort of help. Eric Fitzpatrick with the Office of Legislative Counsel to talk a little bit more about the proposed amendment to 8729. So right now, you're as Chair Yang was saying, the general statute of limitations for civil claims is 6 years. There are some specific statutes that make exceptions to that. One of them is for personal injury claims, and that would include emotional distress, and personal injury, things like that arise out of personal injury, and that's 3 years. But if you imagine, for example, an employment discrimination claim, it could give rise to claims of both of those types. You could have a claim for lost wages, right? And extra damages, that would fall under the 6 years. You might have a claim for reinstatement, injunctive relief. You want the court to order you to say that was discrimination, give this person their job back. That would also fall under the 6 years. But you might also have a claim for emotional distress, for emotional injury that arose out of discrimination, of discriminatory conduct, that piece would be subject to the 3-year statute of limitations. So the same incident would give you different limitations period for different elements of your claim. So the proposal is to make clear that in those types of cases, discrimination in employment, discrimination in public accommodations housing, it's always 6 years, which it would be anyway for parts of the claim.
Okay.
But it makes it, I think, as Chair Yang said, less confusing that you don't have, well, there's your personal injury, your emotional distress pieces of your claim had to have brought in 3 years earlier than the rest of it.
And that's kind of counterintuitive because personal injury, I don't see why that should be half the time that you would, anyway, thank you, I appreciate that.
Yeah.
That's very helpful, Eric, actually. That's why we probably, I'm supportive of this. I don't know if the rest of the committee's okay with adding this to as a floor amendment to the bill. I guess we have to do it as committee members. Is everybody willing to sign on? Okay, great. Great. Thank you, Board.
Thank you. Thank you very much. It was lovely to see you all again and have a happy birthday. Take care.
Good to see you, board.
Good to see you. There's one other amendment, Eric. Right now. Okay. Okay, two more. This should be familiar. It's the same language we passed yesterday.
Oh, I see, just give it 2 rides.
Yeah, because the concern is if we don't, these things would be lost if the governor were to veto. If the House concurs with us, which they're likely to do. So, Eric, do you want to just, I mean, I think everybody understands, we went over these before, but make sure we all understand what we've got here.
Sure, yeah, as you said, Senator Sears, I believe it was H 534, a ceiling bill that had the first proposal of amendment, which is 5, 5A, and 6 in them that you passed already. Now, as it happens, also, the last piece of that, section 6, unauthorized disclosure, is also in the miscellaneous bill already. So we were trying to keep track of both of them so that they could be trued up. So, if the happenstance occurred that both bills were passed, you want to have them identical. You don't want to have 2 different pieces of language passing that are different. It has happened before. It's always troubling to deal with. So, now the first thing, so that's what this does. It takes the pieces, it makes it clear the stuff that you already passed in 534, makes it exactly the same for purposes of 729. So that.
So this would strike the, go ahead, I'm sorry, I'm interrupting.
No, that's all right. That's brilliant. That's all it's doing.
The unauthorized disclosure would strike the section that's in the current version of the bill and insert this, right?
So I think, thank you for pointing that out, Senator, because I think there might be a typo here. Not a typo so much, but again, this is why it's so hard to keep these different pieces consistent when they're in different bills. I think that, if I was hearing Michelle correctly, that when you guys were doing 534, and I'm looking at page 3 of the amendment now.
Yes.
I want to make sure this language is consistent and identical. And I think that when you pass 534, the without authorization language might have been, I'm trying to remember whether that's, well, I'll have to double check it to make sure.
The committee did quite a bit of work on this.
Yeah.
This is the same language.
Ceiling.
Right.
Senator Baruth was really active.
Right.
drafting of it.
So there was that language that struck that had to do with in the course of their official,
Right.
something like that, so that's gone, which is
Now
good.
this says both, this language appears in both bills.
Yeah.
So it's consistent, it's identical, okay, good.
Yep.
Yeah, so, but this language would strike the language that's in the other bill, in the miscellaneous bill.
Right, this would take the place, yeah,
So
exactly.
when you draft this, it would be worded that.
Oh, I thought this was going on in this bill.
It is,
Oh.
but there's already a section.
Oh, I see.
for
So- so we don't
disclosure
have-
in the miscellaneous bill. We need to strike that and insert this in lieu of that.
Got it.
Correct. Which it does, at the very intro, you'll see line 3 of page 1. That's the word, see line 3 strikes 5 and 6.
Yeah.
I guess one,
Page 1, line 3.
why are we getting, why is the attorney specifically mentioned versus some other type of person in the contract?
No, it's including us.
An employee or a contractor.
But why do we specifically say an attorney?
Oh,
I think it's just making it clear that, and it's anybody who's an employee or contractor or agent.
Why,
Those are just some examples.
seems weird to have an example of sort out an attorney there versus some other kind of person who might be a contractor or agent of the court. How about a guardian ad litem?
Well, it's including, so it would include anybody.
But why do we say specifically an
I don't
attorney?
know, that was Michelle's draft.
It seems weird.
Well, I
would
think,
this cover law enforcement? Because it says
yes,
of the court,
Agent of the court.
agent of the court. Are they considered an agent of the court? Law enforcement?
If they're courthouse security there.
No, I don't mean the courthouse.
so maybe.
They're a
we should
municipal
get-
employee.
Would you like to have Michelle go over this again, Alice?
I'd like to know a little more about it, why. I
Well, we already-
Phone,
Yeah,
have this language.
Yeah, you did.
Yeah.
It is
Yes,
covered.
the attorney
We already
file.
passed
It is. And it says a state or municipal employee or contractor
Yeah.
or any agent of the court. So it does cover law
so
enforcement.
if
So why doesn't just period stop there?
you work for Eckhart,
Yeah.
you had access to confidential files, kids.
Right.
We're a contractor, technically,
Yeah,
of
yeah,
the
I get
state.
that, yeah.
And so you would not, in your official duty, you could see whatever was on that kid. But you're not to disclose that
Yes. Yeah, I
to
know that.
other people.
Right,
And this just makes clear that's illegal.
okay, I know a lot about not revealing information during adoptions forever, which were at times very secret, and also I went to court once. Got brought into court because of a case that someone had spoken to me about adoption, had their baby and absconded. And the court called me in, I thought I might go to jail that day, because they wanted to know where the mother had gone with the baby, because the father wanted to get the baby. And the sheriff came, and I had to go to court, and I thought, well, I'm not revealing this, what I know,
Right.
and I didn't. I said there was another route where they could find that out, which of course they didn't find it out, but it was like very scary, because you said you have to reveal it, I said, I'm not, I'm bound by
Right,
the
another law
confidentiality
that
of my situation, I won't reveal it. They said, we won't charge you, and I don't care, not revealing it.
Well, this would be the reverse. This would
Yeah, I know,
protect.
But
But
my,
Alice, I think your concern here is that we're pointing out attorneys.
yes,
And I think the reason for that is because any agent of the court, including an attorney and an employee or a contractor of the attorney. So it isn't just the attorney, it's the employees in the attorney's office. And if he contracts with a PI, for example, it would cover that person too. I think that goes beyond, because a PI wouldn't necessarily, working for an attorney,
PI, personal investigator.
private investigator, wouldn't necessarily consider himself an agent of the court, but he's an employee of the attorney. So I think you
Yeah.
have to make it specific to, also to
Yeah, and
attorneys.
it seems like the including there is making sure that people understand it's not just the inner ring of the court, it's this
Yeah.
outer ring that
Yeah.
accesses.
I know, I realize it's contractors or whatever, but I just thought this seems like the singling out, because maybe they must, whoever wrote it, Michelle maybe thinks maybe they'd be more apt to give information out. I don't know.
I think it was actually proposed, I mean, it may have been Michelle drafted, but I thought this has been sitting in the exact same language actually is in the juvenile bill. For juvenile proceedings. So it's been passed and it's been in the miscellaneous bill for a while too.
Yeah.
So, and I vaguely remember that it was proposed by some folks who worked on it. It wasn't, not necessarily an original draft of our office. I could be wrong. You might want to double check with Michelle, but that's what I thought I recall.
I mean,
Because it
certainly-
predated her involvement. It was in the juvenile bill.
Well, part of it started, Senator Baruth, in our discussions, wanted to make clear that, you know, the unauthorized disclosure was just part of your duty. That was
Yeah.
what we did, and we expanded it, even if it wasn't part of your official duty, because originally the language was as part of your official duty.
Right.
So technically, I'm not on duty, so I can reveal it all, which that's where the major change came in from the one we did in the miscellaneous bill.
And was there a fine before?
I believe so.
Yeah.
There's always been a fine. So is everybody okay with these changes to that?
Good.
I'm trying to explore, and we can do it next week if we have to. We can't get a hold of Charity Clark.
Well, like,
Remember the robocall bill?
yeah,
Well, the House, the second biennium in a row, is not taking it up.
okay.
Evidently, they like those calls.
They like them?
They must like them
Oh,
because
they
they
didn't
don't
take it
take
up.
up the bill.
Oh, okay.
And Marcotte says, well, you know, told Randy Brock that the reason they weren't taking it up because Jerry Clark said it wasn't necessary. I don't know that she said that, but I'd like to hear that from her before we add it as a floor amendment. So is everybody okay as being on this floor amendment to the one we have right in front of us now? Is there any objection?
Is it on?
Charity Clark, I remember her saying that it would probably be relatively unenforceable, but that it wasn't harmful.
Right.
That's what I remember.
I just want to make sure that
It wasn't.
that hasn't changed, because
Yeah.
I talked to Randy, and Randy and I may just put it on the floor anyway, but I just wanted to be aware of that. Because I'm tired of getting these. You know,
Man,
every time they say this is your last chance, they don't mean it.
Did you notice, Senator, that so the discrimination piece is in there too? I folded it all into one amendment. I don't know if
Oh,
that's
okay, yeah.
The way you want to do it, I presume, once you, the one we just talked about before.
I see.
Yeah, you didn't get to talk on that, Jeanette, so you don't want to.
On which one?
The changing the statute of limitations on discrimination.
It's the First Amendment,
It clarifies it. that it's
effective as fun.
6 years for all.
Oh, okay. All right. Is that, everybody okay with that?
I guess I'm okay with signing on. I'm a little nervous about the fact that there was never any testimony anywhere from anybody that might fall into the category of being an opponent.
It makes it 6 years. for
Well,
everybody.
it is 6 years now for most things, but then personal injury and emotional distress are 3,
Right.
and it's confusing if they're wrapped up into one.
Well, I've gone, you know, I've cleared this with Representative Grad. She was okay with it. She's okay with both.
so can I ask a question? So Eric, from what somebody just said here, is it moving personal injury to 6 or is that going to say 3?
Only for these types of claims, not general personal injury. That will stay free for general situations, but specific to housing or employment discrimination claims, those would all be 6 years, and that would apply to whether the claim was, for reinstatement or for a declaratory relief, anything like that, which already has 6 years now, or your emotional distress piece too. So it's all your claims that arose out of the same incident would be covered by the same 6-year period instead of some being 6 and some being 3.
What time does Ben have to leave?
11:15.
Yes, sir.
On the note of signing on to it, I'll vote for it. I don't want to.
What is your day like, Eric?
Which day?
Today?
Well, he's with us now.
Yeah, I'm here for the rest of the morning, or at least until we're,
Till 10:30,
Okay,
and then Ben comes.
and then Ben comes in. If we don't finish it, we don't finish it.
Which one?
What one?
533, the civil forfeiture.
Oh,
So should we hold this amendment for now?
I was thinking, why are we doing this? It just continues to crop up in my mind.
What?
Should I hold on to this amendment for now, because we might add,
No, I think we'll do this amendment, put it on the calendar
okay,
with the bill. And then if Senator Brock and I decide to do the robocalls, we can take that up next.
okay,
Unless we can get Charity in here.
right.
She's not responding, so
She's not responding,
I was like, if I invite you now. can
which
you
is
join?
fine.
Yeah,
We can do it on next Wednesday, before the third reading. This would be on notice today, second reading Tuesday. This would be on with the bill on notice on, so it could be taken up on Tuesday as part of the bill. Then before third reading, if we decide to do the robocall, we can do it.
Is 729 on notice today? Because finance voted it out yesterday or something, so it's on the
I
calendar.
haven't checked the calendar yet.
I didn't check either.
I can love it.
Probably a good idea to check the calendar. Rights, it is slow today.
Everything is, it's,
I have the third reading of 107,
we're looking for 729, you said.
79,
729.
page 548, miscellaneous cannabis is
729 is on,
notice.
on. Notice calendar second reading, that's for today.
Yeah, but
Enact relating to miscellaneous judiciary report center, Sears Finance Report Center, Hardy.
they must have done something.
No, they didn't. They just, the report is just that it's okay with us.
Oh, okay, that's nice.
I was in there yesterday for that.
But definitely not up until Tuesday, so we're fine, we got time to put this on the calendar.
Right. Then you can bring that to John Bloomer, and you're all set with that one?
Yeah, well, I've just written over this, so I need a formal.
Right.
This one,
Got through the 2 pages, Jeanette.
this 2 pages, is that what you're speaking about, Senator Sears?
Yeah, but you've got to add all the names to it.
I don't want my name.
Senator Nixon doesn't want her name.
Of which one now?
These-
About the landlord.
Is there anybody besides who doesn't want their name on it?
Where, tell me which one it is.
The two that we just discussed.
Oh, okay, I thought
The
you said,
effective expungement,
you know, I thought you were going to
effective sealing.
landlords.
It is
and
about,
it just strikes the current 5 and 6
Yeah,
and inserts a new 5, 5A and 6 into the bill as seen in this document.
Just to be sure, and then I'll send to you with the other senators' fine. Everyone else is on it.
Actually, the last one, section,
it's confusing.
sorry, what's confusing? Section 38 has to do with, right now, Eric, you did a great job explaining it. Would you mind doing it again?
okay, and you don't need to, I see
On,
it now, public.
Effective discrimination.
Or
that-
housing, yeah.
If your concern was employment or discrimination, correct me if I'm wrong. This is my test for the floor.
Right.
If you're claiming certain violations, it's a 6-year statute of limitations. But if you're claiming that you should have your job reinstated, it's a 3-year statute of limitations. If you're claiming
Correct.
job discrimination.
Actually, it's the reverse.
Currently, huh?
It's the reverse. Sorry, just to make sure you're clear
I
on the
think you
floor.
better write this down for me.
Okay. It's 6 years for getting your job reinstated currently. It's 3 years for your emotional distress for getting fired because you were of a certain race or religion or whatever. Assume it was an employment discrimination claim. And you say, I got fired and the real reason you fired me was because you don't want people of my religion or race working there. And so arising out of that claim, you could have, out of that incident, you'd want to claim a few things. You'd want to claim, you want my job back because you can't fire me because I'm discriminated. You want my lost wages because everything that I should have been making for that period when you fired me, I should get back. That is subject to the 6-year statute of limitations currently. But you'd also be claiming And I want my pain and suffering, my emotional damages for the fact that you made me feel terrible, because you fired me because of my race, which is totally legally claimable as well. That would be subject to a 3-year statute of limitations currently. So it's confusing that you're bringing all these claims out of one incident, and you might not read. You had to bring 3 years, within 3 years, as opposed to 6 when you had to bring all the other ones.
You're involved in this subject though for employment purposes. Who would you normally expect to provide pushback? 3 year, change to 6.
Well, that's for the emotional damages or,
Yeah.
because that's currently 3. I suppose an employer, I suppose.
Well, the first,
But I don't know that there would be any pushback.
this is typical of, Tom Stevens brought it to me. And I said, if it's okay with Representative Rad, it's okay with me, and if it's okay with the Human Rights Commission, we'll take a look at it, and perhaps insert it. Then I had more emails with Bohr and others throughout this process. Probably ought to make Senator Sorokin aware of it.
I suppose an employer could be upset about it because for 6 years is a long time for
The only thing that's got me on the fence on this one, trying to sign on it.
because 6 years is a long time to say, you made me feel bad. So you made me feel bad.
I don't give a shit about this.
I mean, this person
Oh, we're live, I'm sorry.
It's okay, it's okay. I
didn't, you know,
yesterday
I
did a
really,
lot.
this, we're trying to help out somebody, and it's a typical move around here. Last minute, they're trying to find a vehicle. I'm convinced that it's a good thing to do. Right? But if you want to take it out,
I also support it. I don't see why you would have 2 statutes of limitations for the same event. So on that basis alone, just rationalizing it out.
It's interesting that we're changing it to the 6 years for
Eric,
both
would you
instead
please
of
send
going
a
back
copy
to
of
3
this
years
to
for both.
Yeah.
Senator Sorokin
6
and
years
make
is a
sure
long
he's
time.
okay with it.
should go back to 3.
Or should I make Tom Stevens do it? I don't know.
I don't think Eric heard it.
I just said, Damien, because as I say, this, I didn't have anything to do with this in the House. It was in the bill that was in House generally, it's 329. So I'm just asking Damien, who was counsel over there, whether any of these folks testified up there, whether they heard from anybody.
Okay, thank
So
you.
this
Yeah.
wasn't even in judiciary.
Correct.
This
Yeah.
was in, oh,
But the other thing Bohr said was that she didn't recall anybody that was invited in to testify that was opposed. And she didn't recall anybody from the landlord community being called in to testify.
Let's do this. Let's separate the two, not do them all at once. I think everybody's agreeing with the section 5 strike and making the effective expungement, and 5A the effective sealing, and the issue of unauthorized disclosure, the new section 6. And then just put myself and Senator Baruth on the discrimination. And in the meantime, we'll hear from, we'll make sure Sorokin's aware of it, and make sure that Damien has talked to Michael Sorokin about it.
All right.
Is that okay?
That sounds good.
Did you say everybody on the first piece? I didn't just. make
Yeah.
sure.
Yeah, I don't think there's any disagreement. We already voted on it.
Just off topic, but coming in, I was listening to VPR and they were talking about the medical monitoring bill being signed.
Yeah.
And I was like, oh, great, you know? And then they said, you know, the medical monitoring bill would do this. And then they said, shouldn't it Senator Michael Sorokin? And then they had a clip from Michael talking about it. And I was like, what did Michael have to do? Like, I really,
the press is, I have to say, this year, I think we've got more things wrong than ever before. And they probably picked that up from there and are gonna,
nothing against Michael, it's just it didn't go
No.
through his committee or
yeah,
whatever. I was interested, was it gonna be you or Campion?
Yeah.
right, right.
I never asked me.
Right.
The governor at least complimented me.
Yeah.
Well,
he should.
Yeah.
Yeah, he should.
after
All these years.
putting us through 3 versions of it.
Putting us through it.
Well,
This is coming
the
in
whole,
from 551.
the whole committee had to.
Okay, now we're at 551.
Yep.
Thank you, Eric.
Yes.
All right, so we're all set on this, Eric?
Yeah, I think, 729.
Yeah.
Yeah, I think. Path forward on that one.
Two of them, two separate amendments.
Right.
Now we're on to 551, which I don't intend to vote on today, by the way.
Oh,
I intend to try to get as much information and try to get us to a point where we're agreeable with the language. This has become a little more complicated than I expected.
actually, I think it's less complicated than I expected, but it's been made complicated.
Oh, but yeah,
Yeah,
don't forget,
I know,
I will repeat,
I know, it's
become more controversial than I expected. But I had, maybe has decided to go in a different direction from the House. Certainly, this committee's prerogative, I should say a majority of the committee has decided. So Eric, could you please go through this new version?
Yes, I'd be happy to. Again, for the record, on 551, it's Eric Fitzpatrick with the Office of Legislative Counsel. Here to talk with the committee about a proposed possible strike-all amendment to the bill as it came over from the House. This is the act prohibiting racially and religiously restrictive covenants in deeds. And the committee, as the chair said, has been having a substantial amount of discussion on this and is trying to think about what direction would be the right way to go. So for purposes of discussion of a next draft, which is what you have in front of you, you'll see there's some language highlighted which kind of brings forth some decision points for the committee to think about. And the first one had to do, I remember the Senator Sears, you were asking specifically that some language be included to make clear that whatever changes are going on in this bill does nothing to change or limit or in any way impact the existing land record, the documents that are in the land records right now. So the historical record isn't meant to be changed by this. And that's because if you think about the way this ordinarily happens, these restrictive covenants are either in a deed or frequently they're in a separate list of covenants that are also recorded in the land records, and all of those things are recorded. And whatever the bill proposes to do, whether you include an ability to release the deed from the covenant or not, it doesn't change the fact that the language still remains as it is today. So that's what the language in the legislative intent section stresses first. So if you look at the bottom of page 1, over onto the top of page 2, it sort of continues from the current legislative intent, but it does strike. You'll see page 1, lines 19 and 20. And this, again, I know the committee's going to discuss this further. You may go either way on this, but if you do decide to strike the release, filing that document in the land records to release it, you'd also want to strike that language on lines 19 and 20 in the intent section where it says, hey, the intent of this is to, well, I'll just read it starting on line 16 so you can see how it would sound. It's the intent of the General Assembly that this act prohibit racially and religiously restrictive covenants from ever being used in Vermont again, regardless of their enforceability. And that it, and then you're striking, establish a process for the removal from existing because you may want to strike that. So continue on to say, and that it ensure that existing racially and religiously restrictive covenants remain in municipal land records to preserve the historical record and maintain critical evidence of a pervasive system of discrimination that existed in Vermont and throughout the country. So you highlighted that point so that you're making clear that the historical record isn't being impacted by any of this.
Can I just stop you for a moment? Line 19. I want to look at the word removal and make sure for public record purposes, you are not, even if we adopted the bill in toto as it was presented to us, and that there was a proviso for somebody to fill out a document and have it filed. You are not removing the language from the existing chain of title.
Right.
You are in effect making simply a public statement that you disagree with whatever's in your title. So the word removal is kind of a misdirection, if you will, for people to understand exactly what's going on. And correct me if I'm wrong, Eric, but we are not removing anything from the chain of title. We are simply giving somebody the opportunity to put another document in the chain at a later link that they disagree with whatever was in their previous chain.
When you say we, you're talking about the House.
Sure. Yes.
Just to be technically correct, the House
Yep.
wrote it to be removed. We are explicitly stating that they're not removed, even though you're technically correct, that the House was incorrect in the idea that they could remove it.
Yeah, it's a really, it's such a crazy paradox, because if we pass this language that Eric just gave us, then we're saying the reverse, which is the state insists that these never be removed. And I don't know, does that mean a landowner couldn't search their whole title and create a new title to remove it? Because it's,
You
You can't do that.
well, so I guess what I'm saying is, if we pass the bill as the House sent it to us with that change, it would still be the certificate. So that a person would have a way of saying, I disavow this part of my, what's in my record. If we don't pass the certificate thing, then we're saying to landowners, if it's discovered that you have one of these covenants, you can't do anything about it. And we insist that it remain there. Whereas the original bill said, if we find out about it, we're gonna have a process to get rid of it, and you can put a disavowal on it. Now we'd be saying, nobody can get rid of it forever. And that seems like a more controversial thing even than we started.
But you don't need to get rid of it
Eric
because
has a
it's
thought.
unenforceable.
Well, it's unenforceable now.
Wait, Eric has a thought in the middle of.
Just to add to that, first of all, sort of respond to both points. I think Senator Banning is correct, and that whatever you do, well, it may depend on what you do, but if you do decide to keep that, I think you're right, the word removal is a misnomer. And that we're gonna have to, that language needs to be changed, because it's called a certificate of release, doesn't remove it from the land record. So that language would have to be trued up somehow, so that it's a process for release or something like that.
More like a disavowal. I mean, you are simply saying, I recognize I have this in my chain, I disavow any association with that chain link.
Right, and I think the effect of it would be that it's no longer subject to that covenant, and it's, I think.
Well, that may be true, but that's exactly what we're doing with the bulk of the bill, which is to declare for all time, these are just not acceptable and will not be enforced.
Right. So with respect to what could one person do, assuming that we're not there, just as two thoughts. One is an example, because I know it happened in our neighborhood when we had this restricted covenants. In our case, it was in a separate list of covenants, and covenants dealt with all kinds of things. You can't have a business in your house. You have to have a setback. You can't do this and that. It just happened to be that was one of them. So what we did was this is a lengthy process, but we had a majority of residents in the neighborhood voted to refile the covenants, and we struck that language so that it was refiled in 2004, I think, with the South Burlington land records, and it didn't have that anymore. So there, at least in that situation, there was an option to remove it from the land records.
Is there for an individual homeowner?
That's what I was gonna say. I think, I don't know this for sure, but if you can ask Dan or another property attorney, I know you can file a corrective deed.
Yeah.
So, but what does that mean?
It
That
doesn't mean the other one is taken out. Like you said,
Right.
that you got rid of it. I mean, you did not get rid of it because it was still was it in the deed or just in the side covenant?
it was inside covenant?
Yeah.
So you didn't take that, you didn't stop the history that went back. You just put something in that was now in the covenant, was now removing it for the
Yes, so now
future.
there's two different, actually three in our case.
Corrected side cover.
There's a set of covenants that were recorded in 1940 something, and that one includes
Yeah.
that, the racially restrictive stuff. But there's another covenant that was recorded in 2004, and where it says subsection F, I think I have it, shortly, I'll see it. It just says deleted,
Deleted, okay,
So-
but the other history is
it's
there.
still there.
Correct.
That's the key point, though. I mean,
It needs
what
to
I
stay.
wanted to have in the bill is a statement that we're not removing history.
Right.
Any more than, even though slavery was abolished, you can't change the fact that Thomas Jefferson owned slaves. That's a fact, it's a historical record, et cetera, et cetera. And even if he just lives to disavow it, I think he may have actually, it doesn't mean that he didn't. And that, I think, is the important point that I wanted to make sure was in somewhere in the intent of this bill. That, when we did the constitutional amendment that's gonna be voted on, we're changing our constitution to make clear that we're taking that reference to slavery out. That doesn't mean that we can undo what was in the Vermont Constitution when it was drafted.
That's correct, yeah.
I'm glad you focused in on that, Senator Benning, because that word removal is, I think, a lot of the confusion about this bill. That as it passed the House.
Shouldn't have removal anywhere in there.
No,
Because
on
we should
page
never
one,
remove anything.
page 1, 2, it says.
Yeah, the word is very bad and misleading.
Well, I think, if I'm looking at the struck language, they wanted to create an actual process for their removal. And,
Well,
That's not what their form does.
no, I understand that, but I
That's right,
think they
that's
were
what they said, yeah.
contemplating a short and a long-term, solution
It's
where,
terrible.
and maybe that's where, Mark Hughes's, concerns
Yeah,
stem from.
yeah, yeah. Right.
On that note, I think probably just to be safe, on line 16 of page 2. So in addition to it being in the intent section, I also put it in here, so subsection B, this section shall not be construed to remove. I think the or alter is probably not helpful now that I read it, because, I agree that what's going on is that, like you're saying, Senator Benning, it's a disavowal. It doesn't, I just don't want, just alter, it just could potentially be
Yeah,
later on, the court might say, well, what did this anybody alter? We understand it's not being removed, so just rather than,
Yeah,
it raises a can of worms, and maybe you don't want to. But remove, I think, is the correct thing of what you're trying to say, that they don't remove them.
I'd like to give them the idea that
yeah.
you could remove them.
Right.
So does the certificate become a certificate of disavowal as opposed to release? Because you don't have the legal power anymore if we advance the rest of this bill to officially release something.
And you're not bound anyway.
Right.
So you can't be released because it's already been ruled unenforced.
Unenforceable, prohibited.
On line 13, that's what you said. Shall be void and unenforced.
And I still come back to saying that that's really the only thing we need to do here. If you set up a certificate that has to be created and filed, that's gonna cost somebody
Yeah.
money and time.
Well, I thought
What
this
is
was
the
free.
purpose?
The House believes that this is free.
You still-
Terry, is this free? Terry Corson?
Only the recording page is free, but you've got to pay somebody to do the research on your title. They're not gonna do it
Yeah,
for
you
free.
see the form itself calls, there's a blank line after deed, book, and page. So somebody's gotta go through the chain of title to figure out what that is. That doesn't come free.
I think you pay for every page that you file. Terry, could you weigh in on that, please?
It says here that they would.
Well, this says it, but in
Right.
reality, you do pay.
Yeah.
She's not here yet.
The fee is.
Terry, are you there? Terry Corson?
That,
But you're gonna pay for somebody to research it.
Never mind, it's okay.
There's Terry now.
Okay.
Terry, we're just checking in.
Yeah, my understanding that there would be no filing fee
Be
or recording
louder.
fee, but, oh, sorry. It's my understanding that there would be no recording fee, but you're correct. You would need somebody with expertise to be able to do the title work.
There is a recording fee too.
No, there isn't.
Well, we would take, we're trying to take it out, but there's a recording fee normally.
Yeah, there would be, but she said in this bill, it takes it, it removes it.
I would just go back to where I was yesterday, which is, I think what Joe talked about yesterday, which is limiting the bill to, you know, you can't produce these from this day forward, and they're nullified going backwards from this day. That seems to me unobjectionable. I can't see why anybody would object to that. Seems like the problem is the certificate and, you know, all the various questions about why you did it, why you wouldn't do it, how you're gonna do it, who's gonna pay. That seems to need a little more study. And I know the chair said that that would constitute rolling, which I don't want to do.
Oh, that's okay.
But that's what I would be comfortable voting.
I'm fine with what you want to do to change this. I have no,
You know, if you get caught in a pickle, I'll be happy to go and explain to the House committee what the rationale is behind this discussion.
I'm not in a pickle. Here's what I believe personally. Having these in the land records is historically significant. It tells us about a time in Vermont history where for whatever reason, these racial and religious covenants existed, and it shows us a discriminatory pattern in that history. That cannot be removed. That is no different than other behaviors. You know, and I remember being shocked when I read a old Boston Globe article, piece of newspaper that had been saved by my great uncle because he had taken a photo in it. But in that paper, that page was ad for jobs. No Irish need apply. That was in the Boston Globe. That's, you know, a history that can't be erased, that there was that prejudice against Irish, for example. Not conflating Irish with others, but we have a history of discrimination in this country. That's what I don't want to see removed. I want to make clear, I thought Mark Hughes made great points about that. At the same time, there ought to be a way to get rid of this. And if the majority of the committee wants to have it written as null and void and stop there, I'm okay with that. You're not rolling. Representative Brad had asked me to pass and concur with the House version. That's obviously not possible, given the testimony we've heard. So I can live with all of this.
I agree with your, the first part of your comments about making sure that it stays there as a record, because it is part of the history of Vermont, and we should acknowledge that. I am a little bit fearful about the certificate that somebody puts in. As you probably know, I've gotten myself into some trouble in both this committee and my other committee, or in many ways. And if I should choose to run again, and I know that this isn't applicable now, but should I choose to run again, and I didn't pay someone to go back and look at my deed to see if there's that restriction there, and then somebody, my opponent, says, look, she has that restriction in her deed and she never filed this release, and that can be used against me. So I think that while it might be a nice idea to have people file those releases, I'm afraid that many people won't pay for a title search going back 200 years. I mean, my house is about 180 years old, and I can't pay for somebody to go back and do that title search, and so I won't know this because I don't know the page and the book number of the original title where it exists. And I don't want it to be used against me.
You're not talking about a hypothetical here. William Rehnquist.
Right,
He was
yes.
still an attorney.
Yep.
Bought a camp on Caspian Lake.
Right.
He went through the 40-year look back for chain of title search, found nothing
Mhm.
offensive, and then bought the property. Fast forward to the day when he's being brought up for consideration for the United States Supreme Court. Opposition research produces something from prior to that 40-year window that they're looking at his title, and finds that this restrictive covenant is in there saying no Hebrews are gonna own this property.
Right.
And it's the kind of thing that sets all of us up for a potential problem, but it just shouldn't be. He had no power to go back in time and actually physically remove that clause from his chain of title. That's problem number one. The only thing he could have done with this is effectively say, I have now located this, and I'm going to add another link in the chain of title that says I disavow what this was 200 years ago. And that may be, if you are looking for political correctness and you want to feel good about saying something about your own title, I can understand having a form that says I disavow what appears in my title once you've learned about it. But this is not zero in cost. You have to literally go back beyond the 40-year window of a normal title search and dig into the entire history of your chain of title, locate the book and page number. You can see that right on the form here. And then you got to pay somebody to do that process. So I don't envision every Vermonter going to pay a lawyer to go back through 200 years worth of title search and find out if they've got something in there. And if so, then file these documents. It just makes no sense to me.
The committee's at a point where they'd like to see a draft, which just makes it null and void. It's clear Vermont law is null and void. Is that my sense of the?
No, but that keeps that has that B section there that it shall not be construed to remove racially or prohibited, that contains that section.
And also prohibits them going forward.
Yeah.
Mhm.
And I think that is it.
I have one thing also. In the legislative intent, this, line 12 and 13, this practice was responsible in part for preventing Americans of BIPOC. Now, quite frankly, there are many people who don't know what BIPOC means, and we shouldn't have something that's an acronym in there. It's not just Americans. It should read, I think, this practice was responsible in part for preventing persons of, I guess you could say, minority races and.
Well, I think you could, instead of using BIPOC, you could state what it actually is.
Yes, and religious minority, our Jewish people, many of these were anti-Semitic is what was going on. And is that?
Well, I wouldn't be surprised today if there are covenants with Muslims.
I don't know, but we need to, and it's persons, not Americans, because there are people
Don't
who
forget,
are.
at the time before World War II, there were many Americans who supported Hitler. And,
Yes,
you know, I think it was called the Fund.
I mean, all you have to,
Lindbergh was one.
all you have to say is this practice.
Lindbergh.
Charles
This
Lindbergh.
practice was responsible in part for preventing racial and religious minority backgrounds.
There you go.
Because that's what we use in other places, is racial and religious background.
Preventing, I agree with that, for preventing persons of racial and religious minority backgrounds.
Yeah,
Mhm.
yeah,
Okay, good.
that's all you have to say.
Okay, so that's the direction the committee's going in. Eric, I wanted to give an opportunity for Mr. Hughes to make some, or Reverend Hughes to make some brief remarks. If he has any, if he'd rather not, that's fine. Mark, if you want to make a couple of remarks, has to be brief because we've only got a few minutes left.
Good morning, Mr. Chair and committee, Reverend Mark Hughes, of Vermont Racial Justice Alliance.
I'm wondering if the volume for everybody is turned down, because everybody.
We're trying to get your volume.
Make it
turned
louder.
up.
Are you having problems hearing me?
Oh, there you go.
There you go.
There you go.
It worked, now it's okay.
Was technical on our part.
Thank you. I just wanted to just thank the committee for taking some additional time to take some, put some consideration into what we're looking at here. Again, as I said in the correspondence that I just sent over to the committee and Peggy, we're concerned about the premise, the process surrounding and the priorities surrounding this policy. We're concerned about the fact that, you know, this conversation, even as it has ensued within your deliberations, it really failed to have a conversation about how, you know, how do we dismantle systemic racism? There's a lot of conversations about how do we remove or how do we break the chain of relationship from the restricted covenant specifically to the deed, the impacts that it has, the cost associated with it, where folks would have to do it, and even the political implications of folks who maybe couldn't, or maybe the fact that folks who were going to do it couldn't afford it. To eradicate systemic racism, the work first involves gaining a clear understanding of our history as a nation. The second aspect of that work involves the collection of racially disaggregated data. And it is upon that point where most of our concern lies, because that really should have been where this policy was centered. Because there's no one in the committee today that can say, well, how many instances does this, how many instances of the restricted covenants associated with deeds across the state exist? I think every single one of us would love to say, not many, but the truth is we don't know. That's part of the work. That's kind of the point. And so and then the last point is civil penalties. If someone chooses to do so anyway, then what, you know, since it is against the law, then what are the repercussions? Are we talking about creating a law that there's no penalties for? I did slightly overlook it, but I'll just briefly go back to it, and I'll just conclude, Mr. Chair, again, appreciating the time, is that the other thing that hasn't really been discussed and that we're missing, and this is, I think it's addressed in other laws, and I've indicated in my previous testimony, is what about folks who don't own the property? What about folks who are leasing, folks who are renting? What about homeowners associations? There was testimony taken in the House on homeowners association, and I think that you know, it was taken into consideration, but I don't see it reflected in this policy. What we know is that only of folks who reside in their houses in Vermont, only 24 of Black folks, only 24% own the houses. And what we know in Burlington is that number is at 0.2%. Shouldn't folks who reside in places that have restricted covenants, if it comes to their attention, have some kind of recourse as well? So I think that these are very complicated conversations, and it goes back again to the emphasis is being placed on what are the concerns and what are the priorities of the property owners, and in this case, mostly the folks who have benefited from generational wealth, which usually turn out to be white people. And so that's what this bill has been centered in. That's what most of your conversations have been centered in. And though the preface or the intent of the bill does acknowledge exactly what the heart of the problem is, the content of the bill falls far short, and all of your deliberations fall far short of true consideration in using this bill to genuinely eradicate systemic racism. I thank you all for your time, and I'll be happy to answer any questions.
Yes, go ahead.
Thank you, Mark. I appreciate it. And I take your points, especially the one that this bill doesn't go far in a number of areas in terms of dismantling systemic racism. My question is, your testimony has been central to the committee's discussions over the last week, and you've convinced us, I think, all of us, that it's more complicated in certain ways than we had imagined. And so what that's resulted in is us constraining ourselves. In other words, we began to see, at least speaking for myself, the certificate that a property owner could fill out. We began to see that as more problematic. And so the committee seems to be coalescing around the idea that we should do what we can do with the testimony we have had in the time we have left. And so what we just talked about is a statement that nullifies these going forward and looking back, so that legally we will have made sure that they are completely without effect. But partially on your advice, we would be making sure by stating explicitly that they're not to be removed from the record because they are a valuable record of a dark part of Vermont history. So with that said, would you oppose a version of the bill that just limited itself to making clear that you can't write these covenants going forward, and if they exist, they have no legal effect, although there is a history there? Maybe if you cut your video, oh, there you go.
Mark, I'd just like to add a provision of Philip's thought process, and that is, this bill does acknowledge that Vermont was not perfect, and we are preserving in the bill the concept of that imperfection.
I appreciate that. And starting with Senator Bayruth, I think your question is what if the bill simply said that it is a matter of Vermont state law that these covenants are prohibited, and further, they shall not be permitted to be used in moving forward.
Right.
Mr. Chair, is that the what the committee member is communicating?
Yeah, that's the direction we're headed.
So again, the difficulty in the conversation is, again, and I just want to remind the committee of the observations that I brought forward last time is that, again, premise, process, and priorities. If you haven't noticed, I'm the only person who's offered testimony who hasn't been a white attorney. And I'm also the only person who's speaking into this process that has had some sort of opposition. And being an African-American and also an activist and abolitionist across the state of Vermont, it puts me in a precarious situation because it places a tremendous burden on me as an individual, and it creates a perception that somehow or another that one might think that I have the responsibility for speaking on behalf of everyone else that this policy might represent. So again, it places me in a very difficult situation to have these conversations with you, and it's just not fair that that's the case. That being the case, I think that for that reason, the best course that this committee could possibly take, given all of the other testimony, given all of the deliberations, and as Attorney Richardson said, the fact that there is no sense of urgency. I find it troubling that the committee just doesn't choose to just table this policy until next session, because nobody loses certainly not the folks who are most impacted, and these are the people who have been deprived of wealth generationally. So what I would say is what we've sent over, what I proposed is the limited non-legal abilities that we've used to take a look at as many policies as we have been able to across the states. I'm sure you have just as much access is to the National Conference of State Legislators and the policies in the various states across the United States as well. We're at a disadvantage because we're not lawyers and we don't have a legal counsel. But to the fullest extent that we were able, we went in and tried to address those three concerns that I just gave you. If they are no longer an issue, and that is to say, if we're just going to say let's just say it's illegal and say we can't do it, then I would personally and only personally have a tendency to agree with Senator Beirut that there's nothing, there shouldn't be a problem with that.
Thank you very much. We're going to turn to another bill now and continue our work on 530 on this bill 551 next week. I'll schedule it for Wednesday morning. Hopefully most of you can make it here. And we'll try to decide what to do. I appreciate everybody's input. Mark, Terry Corsone, and others who have been with us. Eric, do you have enough direction to do a new draft?
Yeah.
Thank you. Okay. So let's.
Before we switch gears, Senator Sears, could I sort of circle us back around to page 729, the miscellaneous bill, just because I did hear back from Damien, just to give you a little thought to walk away from where we're sitting on that. Remember, that was the question of that separate amendment having to do with the statute of limitations for the discrimination claims. So he said on the House side in general, Karen Stackpole and Stephen Ellis are employer-side attorneys from Paul Frank Collins. Heather Lynn represents the Vermont School Board. They testified in House General. Of them, Karen was supportive. The other two were neutral. They also heard from Vermont and Lake Champlain Chambers of Commerce and the Vermont Business for Social Responsibility. VBSR supported the change. Vermont Chamber was generally supportive. Austin Davis from the Lake Champlain Chamber was neutral and questioned why it was necessary. So that's the feedback that they have.
Could you send us an email with that information?
Yep, definitely. I'll forward it.
Thank you so much, Eric.
Yep.
Have a good weekend.
Yes, you too.
Thank you.
We'll be back at it.
Wednesday
Shortly.
morning at 8:30.
That's right. So it's only meeting, am I right? This committee's only meeting Wednesday, Friday next week?
Yeah, 8:30 to, hopefully 8:30 to 9:45. They're going to be on the floor at 10. In conference committee and not available, obviously. I am.
So do you still want to take up those amendments today? When I say 729, do you still want to bring?
Yeah, I would like to take them up today, so they're on the notice calendar for next.
Gotcha. Both of them, two separate ones.
Yeah.
Yep, got it.
And I'll speak to Ciroc.
Yes, sounds good. All righty, thanks everybody.
Thank you.
Thank you, Eric.
All right. One other piece of business. Yesterday, we voted 3-1-1 on a further proposal amendment on 254. You were not in the room at the time. That was the qualified immunity. We added back. We concurred for the proposal amendment, and that was adding back in a section on data regarding, settlements by various towns for police.
So the vote was 3-1-1.
Yeah, and you are the one that hasn't voted yet.
Let's leave it there.
Okay.
Probably better that way.
Good. All right. Another simple little bill, thank you, House.
I'll save that note to you.
So yesterday, Ben came to our committee, much flustered from having just been in the house. And we provided him a safe haven.
Nice.
Did we not?
You did. It was very nice. We had some conversations about cows and cheddar cheese, right?
Oh, yeah, I should tell this committee because, Demo came in, Commissioner Demo, because we were looking at that, commission that was set up to kind of the advisory commission for the DOC. And, they had some changes to make and everybody agreed, but he came in and said he agreed. Rachel set me up and or sent him up and had us ask him questions. And the 4 questions we asked him were, how many times his name was mispronounced and misspelled as Demi. And he said when he got here, everything said Demi. All his passes and his sign, everything. And then we asked him if he would weigh in on which was better, Vermont cheddar or Wisconsin cheddar. And then we asked him if he would consider his job, what he would just use to describe his job, soothing, peaceful, quiet, or a couple adjectives. And then we asked the ultimate Vermont question. How many ticks on a Vermont cow as opposed to a Wisconsin cow?
Oh, he's got an answer.
Yeah, and his answer was, I assume they're the same, but I don't exactly know how many. And so I wrote a note to Rachel and told him that would be his confirmation hearing.
Oh, yeah.
Anyway,
The
it was
one
fun.
question you missed was, how do you say CALIS?
Yeah, we did, yeah. We didn't want to do too many. We were gonna ask him about.
One of the great things about coming from where I grew up, that's in Framingham, Mass, which is halfway between Boston and Worcester, is to watch people try to pronounce Worcester.
Worcester.
Oh, it's all over the place.
Yeah.
I say, well, I'm halfway between Boston and Worcester.
Yeah.
They have no idea. They. Peabody.
And Gloucester. Yeah.
Peabody.
My uncle lives in Framingham.
Let's see.
My uncle lives in Framingham.
Oh, really?
Yeah. His wife was the vice principal of Wellesley High School for many years. Wow. Yeah. She was a force.
They were, until recently, when they became a city, they were the largest town in the country. There was over 100, I think over 100,000 people in the town. They had a representative town meeting.
I told you about being in Sturgis, I mean, in Milwaukee for the 100th anniversary of Harley, and they had all the Wisconsin displays like this one tent. One of them was a dairy tent, and they were giving out free Wisconsin ice cream and cheese to everybody. I walked up and they're naturally asking everybody where they're from, and they asked me, and I said, Vermont. And the woman says, oh.
Say no cheese for
Yeah,
you.
she was touting all the products.
Yeah,
I think that was the year Vermont took the #1 for that.
We have before us draft 1.3. Ben did a walkthrough yesterday, and I wonder if any of the,
Actually, I have to look at 1.4 and the copyright.
we have before us draft 1.4.
Not yet.
I can,
In the future, we will have before.
What is the difference in 1.4? Peggy's going to get it, but I wonder, in the interest of time, because Ben has to leave here at 11:15. If there's any comments from any of the members of the audience, Judge Zone, you have any comments?
No, Tom Zone, Chief Superior Judge, I would note that I had some changes and it looks like Ben was able to put them in on some language that affected the court administrator versus court clerk. So we appreciate that. Beyond that, as far as the matters involving impact on the judiciary, we were fine with the new draft.
Great. I know Marshall Paul has some comments. I'm trying to wait until we have a copy of the draft 1.4 in front of us. But it is on our webpage. So,
Center Street.
If it matters, I do not have a copy of 1.4 and I've prepared comments on 1.3. I haven't seen 1.4, so I'm not sure how different it is. I can try to.
1.4 is on the committee page.
Oh, okay, I'll look a little earlier and didn't see it. Look again.
Why don't we give you a chance to look at that and give us a chance to have Ben give us the yellow highlighted changes between 1.4 and 1.3.
Yeah, and just for everyone's knowledge, Ben Overgroski for the Office of Legislative Counsel, 1.4 was completed a few minutes before the committee, so it was sent to everyone, but it may still be in, cyberspace, if you will. And so, but I can go over what the changes were based off of comments from the Department of Public Safety, the Judiciary, and the Department of State's Attorneys and Sheriffs. So I can go ahead and, I can project this on the screen.
Maybe it's easier if you don't. I'm gonna ask Marshall to try to prepare comments based on 1.4 while Ben walks us through it, and maybe you can adjust your comments. Hopefully we can. I'm sorry to have to do this in such a short time.
Does the web version have the yellow?
It does.
It does.
Yeah, and by majority, if not all, of the deleted language, or at least the affected sections, have been highlighted. So the first change from 1.3 is on page 2, which strikes language on lines 2 through 4 describing derivative proceeds, not including real property occupied as the primary residence of a person involved in the violation and a member or members of that person's family. I attempted to highlight this yesterday as one that was under discussion, and the reason for that is after consultation with the folks that I referenced before, is that might hinder the seizure of property that's acquired by drug proceeds. And so one that might need to be seized pursuant to a law enforcement investigation. And that is sort of in conjunction with keeping the reference to the homestead exemption, is that ultimately the $125,000 could be returned if it's not a part of those ill-gotten gains, essentially. The second change from 1.3 is to 4243A1. This is on page 4, beginning on lines 5 and 6, or I'm sorry, 7 and 8. So in subdivision 1, the last version stated that the state must prove by clear and convincing evidence that property was an instrument of the crime or proceeds under underlying offense. That was removed to be more consistent with the scope of 4241, which establishes what is subject to forfeiture. It was arguably narrower than the scope itself, and based on comments from law enforcement, it was a practical removal because the state wouldn't seize something if it wasn't related to the criminal offense. They have probable cause to seize it. It would be more in line, and otherwise it would sort of be a waste of time and resources. Moving on to 4243D, there was, which is on page 5. This was based off the committee's discussion yesterday about, and also discussion with law enforcement about adding publication in a newspaper. So in subsection D, not only is someone notified, but the state shall also cause the notice to be published in a newspaper of general circulation.
Can I stop and ask a question? That newspaper publication is actually subject to, I wondered why we just didn't refer to the rule instead of saying as ordered by the court.
Well, that was, yeah, it is covered by Rule 4, but this is also tied to the notification of the seizure once the order had been issued. So it may not necessarily be tied always to a petition being filed and service being made in that sense. So it could be changed to reflect Rule 4, but this was also in another portion of the statute that was already in existence. So it was also an attempt to be consistent with what was there, that notice would be made that way when the order for seizure was issued, and also once the petition was actually filed.
Go ahead.
Okay. Also in 42, 43, in G, this was what I was referring to, that petition for forfeiture. So on line 3, forfeiture was added to clarify that it was for that petition, and also to add an extension that the state could obtain of 30 days in case they needed some more time.
60 days.
This is on G on page 6.
Oh, I'm sorry, I was still on the. Thank you.
42, 43I, which is on page 8, beginning on lines.
You did the.
What about page 7?
Oh, yes. So page 7, this was Senator Nick in response to your concerns yesterday that these would become 7 business days from the date of the petition.
And is it the, how does the petition, that's the date the petition is filed in court?
So the date of petition would be the date that the that's listed on the petition itself. So it could be the date, but really the date that it was created,
So is that?
or mailed rather.
So some days after the date that it's created or mailed, which isn't, I mean, I guess the problem is, does it really wind up being like maybe even only 2 days? You're wanting to, person's wanting to request a hearing, and I appreciate the business, but is this reasonable?
I don't know.
Certainly don't seem like it is.
I don't know what, that's why I'm trying to hear from the witnesses.
Well, I know, but here's an issue.
Maybe they can answer, is that reasonable? And you'll, when you're called upon, maybe you can explain that.
Okay. Like
They're the practitioners.
Okay. Next.
Well, and just on that one point, this language was derived from the civil suspension procedure language. And so this process is already, at least on this part, already in practice. And so
Well, let's
it's
listen to the practitioners and move on.
Okay.
Page 9.
On page 8, subsection I, which is the exceptions to the conviction or plea requirement. What was changed is on line 9, there was the evidence that before conviction was initially in draft 1.3. That's been removed to account for the fact that a criminal charge may not always be filed when this process starts. So it accounts for that reality as well. Because, and also for that, that no identifiable defendant may exist at the time that this process starts. Again, accounting for the investigation that may go on, and again, before a charge may actually be filed if there's no identifiable defendant. Subsection J on just below that was changed on lines 14 and 15. Previously contained language saying outlining that a timely demand for a prompt post-seizure hearing was also a requirement, and also subjected it to a 90-day timeline. The prompt post-seizure hearing was removed to really account that, again, a practical reality that someone could make that demand and the hearing would happen anyway, but really the demand for judicial determination is sort of the ultimate determination of the forfeiture itself. So it seems sensible that that would sort of be the tying event. And that rather than putting a time limit when it would file, just to kind of leave it that once the time period for that request to be made had passed, that the state had the ability upon motion to file for a default judgment and seize and forfeit the property. 4243A, just below that on lines 18 and 19. Again, the 7 business days edition and the publication, tying all of that together based on the committee's discussions yesterday. In 4243A, subsection B3, there was removal of the language that at the time, at the same time as the hearing pursuant to Rule 41 related to the action of forfeiture. The action for forfeiture language was removed because a Rule 41 motion doesn't always need a criminal case to be filed. It's anyone that would be aggrieved under that procedure that could file that motion. So it's to account for that reality as well.
Can I just ask the difference between post-seizure hearing and forfeiture hearing first? What is that difference?
So a prompt post-seizure hearing, the intent is that while the petition plays out, someone has a mechanism to seek return of their property before the ultimate determination.
I see, okay. So then my question is, does the bill specify what prompt is? Or is it like language in the Constitution that says speedy?
Well, that term itself is not defined. However, it is informed by the various time periods that, you know, once someone receives notice of the forfeiture, they have 7 business days to file that. And then within that, that it must be scheduled, it was within 60 days.
Well, that's the other one, the forfeiture.
But basically it gives, the way that the language here is written is that it gives the court the discretion essentially to hold it as soon as it can in line with, you know, what is best for the court. So it could be a separate hearing, it could be at the same time as another hearing that's in a parallel case.
Interesting. We specified for the person who's, you know, filing notice that they want a hearing, they have 7 business days. So they have a clock running. And then we repeat the phrase prompt post-seizure hearing like 4 times. So it seems that there's an incredible emphasis on promptness, but I could see courts just saying, we're backed up from COVID. You know, what can I tell you?
And that's possible. I mean, the plain meaning of prompt is really, I think, as soon as practicable. And there was initial discussion both in the House and in the discussions with the witnesses here about really just giving the court the ability to schedule it based off of its own needs. And you're correct. If there is a backlog, there could be a delay there. However, it was just to account to make it work as best as it could for the court system.
Yes.
Subsection C.
Okay.
Also in that, in subsection C of 4243A, it removed that if no criminal charge was filed from the list of reasons to return the seized property. Again, that's just to account for the situation that there may not always be a criminal charge filed when a prompt post-seizure hearing occurs. There was discussion that what is now subdivision 2, that no probable cause exists, to show that that does protect the interests of the requester to a degree, because that essentially would be necessary basis to seize the property in the first place. So it was an attempt to strike the balance between the realities of an investigation and no charge being filed, yet having some protection there for the requester. On 4244A, that's the right to a forfeiture hearing. Again, this is to add language on lines 6 and 7 that publication was tied to the notice, and also the addition of the petition itself, just for clarity more than anything. And 4245A, which is on page 13, starting on line 16. There was a change back to the initial, and this is actually going on to line page 14, my apologies, on line 11, that initially the state's attorney had a 30-day period to either approve or reject a request to remit or mitigate the property seized. It's been changed back to what exists in statute now to 90 days, just to account for a flood of requests, potentially to give the state's attorney enough time to conduct an inquiry and interview if need be. And as Judge Zone referenced before, there were throughout the statute references to the court administrator and filing these things with the court administrator. That has been changed to the clerk of the court, just to be more accurate.
So I just really want to give time. We've got a limited amount of time left. So why don't we start with Marcia Paul?
Thank you. So good morning to the committee, and I will try to be as organized as I can. Frankly, it's been very difficult for me in trying to follow draft 1.4 on the screen without it on the screen. I was able to keep my comments lined up for about half of that, and then I lost track. So I'll do my best. Our office has a number of concerns about the redraft, and specifically, I'm talking about some concerns, and I'll try to refer to them in the 1.4 draft, but there may be times I have to refer to draft 1.3. So to begin with, I think the first change is one of the new changes between draft 1.3 and 1.4, which is on page 2, which would strike the clause defining derivative proceeds as not including real property. And that's one I'm just not sure why that change was made. That's something that's in existing law. That's not something that's new in the House bill that was removed. And I think that Attorney Novgorowski said that that was changed in order to facilitate seizure, but didn't give any explanation beyond that. And I don't think we understand why that change was made and would be uncomfortable agreeing to it without understanding it. On page 5, on lines on draft 1.4, 12 through 14, there's something that's been struck out from the House passed versions, which provided that an agency's return of property due to lack of proper notice did not restrict the agency's authority to commence a forfeiture proceeding at a later time. That's existing law. That's not law that was added by the House. And we would oppose striking out that law because what that would allow is essentially abuse of the process. That would allow agencies to seize stuff from people, and then because they didn't bother to provide notice, to be forced to return it and then just turn around and seize it again. You know, this provides a mechanism where, first of all, there's no real remedy for there having been a failure of notice. Like all of the notice provisions that lead up to that clause are supposed to give people constitutionally protected notice of what they need to do, you know, what's been seized, why it's been seized, and what they need to do in order to effectuate its return. And to just simply say, the notice part doesn't matter. If they get it wrong, they can just return the property and seize it again, really undercuts that entire premise. So we would oppose that. We would also oppose the change in subsection F from allowing from 14 days to 60 days.
Marshall?
Yes.
I'm sorry. I'm just wondering, I'm a little confused on 5. the struck language, an agency's return of property due to lack of proper notice does not restrict the agency's authority to commence a future proceeding at a later time. It seems to me that language that's struck allows what you're trying to prevent. And so if we strike it, aren't we moving toward what you want rather than away from it?
I think it's not clear, and I think that's, again, another part of the problem with this. These most recent changes have been made in a very hurried fashion, and it's not clear why they're being made. And so we're left to try to interpret what the changes mean from the text of the statute, which can be difficult.
Yeah, but if I could, when you look at that sentence, it seems to prevent the thing you're worried would occur.
And as long as that's clear, then we're okay with it. But our concern is that it's not clear.
Okay, fair enough.
So, and I'm going to try to move quick because I know that Ben does not have a lot of time and I do have a lot of comments. So the change from 14 days to 90 days, which is on lines 19 and 20 of page 5, we think is too long of an extension. We understand the concern that 14 days may not be enough, but we think 90 days is a pretty extreme jump. And we think that that especially is important when you line it up with on page 7. We have the provision that requires the petitioners to file their petition within 7 business days. We have a couple concerns about that. One is that it's way too short. That's just simply not enough time to give people the opportunity to receive a petition, understand what it means, get some advice about what they should do, and respond to it. Our other concern is that this just isn't the way that we write timelines. We have a rule that was passed by the legislature several years ago called the day is a day rule that says that what we do in statute is we put in simply a number of days. And then there is no, I know there was confusion in prior testimony about do we count X number of, do we count weekends when it's under 10 days and over 10 days? All of that's gone. That was struck out of rule a few years ago. And the rule currently is, it's in Civil Rule 6, that every day is a day, just to simplify the computation of time. And so, typically we haven't been putting things in statute like referring to business days, because instead we just default to Rule 6 computation of time principles, which say that that weekends and holidays do not count. And that's why, if you remember from that day is a day rule legislation, it was very lengthy because they had to go through the entirety of state statute and change everywhere it said 7 days, they changed it to 10 days. Everywhere it said 10 days, they changed it to 14. They made changes like that to sort of account for the change to every day counting as a day. So we would first of all say that that deadline of 7 days is too short, and also say that it ought to be written consistent with Rule 6 on the computation of time. We also have a concern on page 8 about the provision that says that there's no need for a conviction if someone was deported by the U.S. government. People can be deported by the U.S. government for all kinds of reasons. It's not necessarily, or even commonly, some reflection of their guilt or a reflection that their property should be forfeited. This, to my mind, really goes back to some old principles of law that Vermont was one of the first states to abandon. At common law, we had a principle that's it was the doctrine of felo de se, that which said that if you were that suicides had their estates forfeited. It was a doctrine of common law. Felo de se essentially means committing a felony against yourself, and essentially it said that by killing yourself, you were yourself an instrumentality of crime, and therefore your heirs were not entitled to inherit your estate. Vermont did away with that sort of revolutionarily in our first constitution in 1777. We were, I believe, the first state in, or the first, we were in a state at the time, but the first jurisdiction in North America to do away with the forfeiture of estates of suicides. And honestly, to me, that's what this looks like. What we're saying is, if you've been deported, then you don't have title to property. Your title to property does not exist in the same way that other people's title to property does. You cannot, even though you may not be here to enjoy that property, you cannot then pass that property to your family. You cannot give that property to your friends. You cannot dispose of that property the way you would. Why? Because you were deported. And to my mind, that's not a good enough reason to deprive somebody of the right to determine what happens with their property, just simply the fact that they were deported. We think that people who were deported should be entitled to the same process around forfeiture of their property as everybody else. And understanding the practical difficulties with that, but also understanding what it means to say that just because somebody's been deported, that they no longer have a property interest that's executable, to me is really contrary to our values as a state. Moving on to just make sure I have this as, I have it as page 12 on draft 1.3, but let me make sure I have the right. So this is on page 12 of draft 1.4 at the very bottom. It's subsections A, subsections A and B. And our concern there are these lines that require, for example, for someone who was a user of property that is subject to forfeiture, that for them to defend their interest in that property, they have to prove that they didn't know the manner that the property was used and that they didn't have any ability to prevent the property from being used in that manner. We think that that's inappropriate. That creates essentially a duty for people to rat out their neighbors and friends and family. We don't do that in law. We don't say that, all of us have a duty if we know about a crime being committed to report the person who's committing the crime. What this essentially says is if you are a user of property, if you have a property interest that is shared with somebody else, two people have joint property interests, that you have a responsibility to report any misdeeds of the other person. And if you don't, you're risking your property interest, even though you yourself have done nothing wrong. So this really creates a duty on property owners to police anyone else who has any interest, whether it's an ownership interest, a lien holder interest, a possessory interest, a usury interest, any interest in that property, you all of a sudden have to police their use of that property. That's a whole new property ownership responsibility. I'm not aware of that existing in law elsewhere. And to our mind, it's inappropriate. We don't do that to people. We don't say to people that in order to safely have an interest in property, you're responsible for essentially acting as law enforcement and ensuring that everyone else who has an interest in that property is using it appropriately. And frankly, with certain types of property that may be, it may be very hard to prove that you don't have the capacity to prevent use or that you were not aware of things, because it's frankly very hard to prove a negative. When somebody asks you to prove that you didn't know something, that's very difficult. When somebody asks you to prove that you couldn't prevent something, that's very difficult. Proving a negative is difficult. I would move on to, this is an odd one. So this is on page 13 of draft 1.4. And this is the section 4245 on remission or mitigation by the state's attorney. We're frankly opposed to all the changes in this section, because this is a very, very weird thing that has been done and we don't understand it. This allows people to apply to a state's attorney and then requires the state's attorney to make findings of fact and act on that. This changes, this was a provision that required people to apply to a judge. And that made sense. People petition judges for things. Judges hear evidence, they make findings of fact. And then if you disagree with those findings of fact, there's criteria to apply. Like the judges had to make those findings of fact and conclusions of law based on a particular criteria. And if you think the judge was wrong, then you appeal that. having this be something where you apply to state's attorneys and they have to perform like an interview, which is really a way to take evidence, and then they make findings and then there's no recourse, makes no sense at all. There's nowhere else in law that state's attorneys are required to make findings. There's nowhere else in law that state's attorneys are required to hear evidence. There's no recourse. But normally when you have findings and evidence, you're talking about a regularized legal proceeding where there are standards of proof, where there are standards of review, and none of that would exist here. If the state's attorney said, I hear everything you say and everything you say sounds like it makes sense, but I just don't want to mitigate your property, you have nowhere to appeal that. And if you have nowhere to appeal that, it's really not a right at all. Like this section to me makes no sense at all. And the only thing that we would support in this section would be changing it back to a process of an application to a court, because this weird idea of applying to state's attorneys and having them make findings, and it just makes no sense to us and is really just inconsistent with the rest of our law. Moving on to page 15, going on to, I guess it's all on page 15, which is the change in the distribution of funds. We have concerns about that. This is a dramatic increase in the amount of money that would be distributed to law enforcement. And our concern there is frankly that as we increase the amount of money that's being, that is available, that we will incentivize people to do law enforcement for the purpose of obtaining the money, as opposed to for the legitimate law enforcement purposes that we sort of see effectuated now. And well, I'm not at all suggesting that we've seen anything like that in Vermont. We haven't. Like, absolutely, we are a state where civil forfeiture has not been something that has changed law enforcement priorities or changed law enforcement perspectives. We have seen that happen in other parts of the country. And one of the features, when you see what's happened in other parts of the country where law enforcement priorities really reflect a drive to effectuate forfeitures, is that one of the features of their forfeiture laws are very high awards for forfeiture, very high percentages of those forfeitures going directly to law enforcement agencies. We don't think it's appropriate to see the same types of patterns that they see in, counties outside St. Louis, Missouri, or counties in, the outskirts of New Orleans, Louisiana, or Baton Rouge, Louisiana, or some of the rural counties of Mississippi. We see these horrible forfeiture abuses taking place. We shouldn't be mirroring our laws to look like those and expecting anything different. They have bad forfeiture policies and bad forfeiture practices, and in part that is because they have been incentivized to do so. And this provision, by increasing that, really would do the same. Finally, the last thing that the new draft did was eliminate all of the restrictions on federal adoption. We oppose the restrictions on federal adoption. This isn't about, to us, that was central to the purpose of this bill. Part of the reason to get involved in this bill was to make the Vermont forfeiture statute, to provide it with enough due process and enough functionality that forfeitures would happen in Vermont courts rather than in federal courts. What this does, by vastly expanding the sort of usability of the forfeiture statute for law enforcement, and at the same time not at all restricting the use of federal adoption, is it's just vastly expanding the tools that law enforcement has to affect forfeitures. They can, they have far more expansive capacity to do a forfeiture in this law under the state system, but they also have no restriction on simply doing it the way that we've been doing it all along under the federal system. So really, this is a vast expansion of law enforcement's forfeiture rights without providing those limiting principles that were in the original bill as it came over from the House. I'm happy to answer any questions.
I think it's pretty clear, and thank you for getting through that in a pretty prompt manner. And we apologize for the late notice on the new draft.
Understandable, it's that time of year.
This is that time of year, and never easy. But I think your explanations are pretty clear to me anyway, of why you oppose some of the changes to the statute. You're trying to strike a balance between, basically, you have a forfeiture system currently that isn't used very often. I don't want to see a huge increase in forfeiture, but you'd like to make it usable for law enforcement, and particularly in cases where it's deemed to be appropriate. And I guess striking that balance. And see where the committee lands in the next few hours.
And I would just a final comment is I agree that it's a balance, and I want to be clear that we are not in here. We're not actually opposed to the direction and purpose of the bill. We think that a usable forfeiture, usable state forfeiture system is actually a really valuable and important thing. I was talking to a colleague of mine who's a federal public defender about the number of adoption cases they see. And they see a lot of adoption cases. A real lot of Vermont cases are going to federal court and being prosecuted federally for no reason other than to allow for easier criminal forfeiture. And that, in our mind, that's not a good idea. Things that can be prosecuted in state court under our laws, under our procedures, should be prosecuted in state court. And we should have, if having a usable forfeiture system allows that to happen, then we support it. We just don't support the system that's been outlined here.
Good. Just like fines going to municipalities, that creates an incentive for municipalities to stop people. But what we've learned during the pandemic is the police aren't stopping people as often. During the height of the pandemic, people weren't traveling, so they weren't getting fined as often. So those coffers went down. I'm pretty sure that 80% is the right mark, but I'm pretty sure 40%, 45% isn't either. So I don't know, there's got to be some place in between. In the few minutes we have left, and I know Ben has to leave.
Yeah,
Because it is now 11:15. He gets out of this. So we will come back to this hopefully next week. Warning everybody that the bill may not make it.